At approximately 6:45 p.m. Eastern Time yesterday, a federal district judge in Washington, D.C. issued a nationwide injunction blocking the largest mass deportation operation in American history. The order, spanning 42 pages, stops the administration from removing anyone under the Alien Enemies Act of 1798 until the courts can determine whether the president has the legal authority to use a wartime statute against members of a Venezuelan street gang. If you've been following the news, you've probably seen the headlines. Judge blocks Trump deportations. Administration vows to appeal. Immigration advocates claim victory. Let me tell you what those headlines are missing. This isn't a story about immigration policy anymore. This is the opening move in a constitutional crisis that could fundamentally reshape the relationship between the courts and the presidency. And the reason I'm recording this right now, at 1 in the morning, is because what happens in the next 72 hours will tell us whether we still live in a country where judges have the power to stop the president, or whether we've already crossed into something much darker. Let me walk you through what actually happened, because the legal mechanics here matter. Then I'll show you why the logistics of this halt create a nightmare scenario that the administration might use as justification to ignore the court entirely. And finally, I'll give you the historical warning that keeps me up at night, because we've been here before, twice, and both times the Republic survived by the thinnest of margins. The case is called State of Massachusetts versus Trump. The lead plaintiff is the Commonwealth of Massachusetts, joined by 16 other states, all arguing that the president's use of the Alien Enemies Act violates both statutory limits and constitutional due process. The defendant is the United States government, represented by the Department of Justice. The judge is U.S. District Judge Colleen Cotelli, appointed by Bill Clinton in 1997. Here's what the injunction actually says. Effective immediately, the government is prohibited from removing any individual under the authority of the Alien Enemies Act unless and until the court determines that the president's invocation of the act is lawful. All deportation flights scheduled under this authority are grounded. All individuals currently detained solely under the Alien Enemies Act must be afforded immediate access to counsel and the opportunity to file habeas corpus petitions. The order is nationwide, meaning it applies in every state, every detention facility, every airport staging area. The administration's legal position was simple. The Tren de Aragua gang, a Venezuelan criminal organization, constitutes a foreign nation conducting an invasion of the United States. Therefore, the president can use the Alien Enemies Act, a wartime law from 1798, to summarily deport any Venezuelan national suspected of gang affiliation without the normal due process protections of immigration court. Judge Cotelli rejected this argument in its entirety. Her ruling hinges on three legal traps that the administration walked straight into. First, the statutory trap. The Alien Enemies Act requires three things to be triggered: a declared war, an invasion, or predatory incursion by a foreign nation or government. The judge ruled that a criminal cartel is not a foreign nation. Under the law of nations, the legal framework understood by the 1798 drafters, only a sovereign entity capable of declaring war or entering into treaties qualifies. The Tren de Aragua cannot sign a peace treaty. It cannot declare war. It is not a government. Therefore, the statutory prerequisites for using the act simply do not exist. Second, the procedural trap. This is what lawyers call the APA trap, the Administrative Procedure Act. Even if the president had the underlying authority to invoke the Alien Enemies Act, the manner in which the deportations were ordered violated federal law. When the Department of Homeland Security issues a rule that creates new rights or obligations, it must go through a formal process. Notice: the agency publishes a notice of proposed rulemaking in the Federal Register. Comment: the public gets to submit written data, views, or arguments. Statement of basis and purpose: the agency must address significant comments and explain its reasoning. The administration skipped all of this. It issued what's called an interim final rule that took effect immediately. The government's justification was the good cause exception, which allows agencies to bypass public comment when it would be impracticable, unnecessary, or contrary to the public interest. The judge ruled this was pretextual. The administration had been planning this operation for months. It had time to conduct notice and comment. It simply chose not to because it knew the policy would face overwhelming opposition. Third, the constitutional trap. The Fifth Amendment's Due Process Clause. No person shall be deprived of life, liberty, or property without due process of law. The Supreme Court has held unequivocally that this protection applies to all persons within the territory of the United States, regardless of citizenship status. The landmark case is Yamataya v. Fisher from 1903. Executive officers cannot arbitrarily deport an alien who has entered the country without giving them an opportunity to be heard. The administration's plan was to conduct mass deportations. 73,000 people are currently in ICE detention. Roughly 74% of them have no criminal convictions. The plan was to sort them by nationality, load them onto planes, and remove them before they could file habeas petitions or request asylum hearings. Judge Kohler-Kotelly ruled that this mass processing violates the requirement for individualized hearings. Each person has a right to notice of the charges against them, a meaningful opportunity to present evidence, access to counsel, and the ability to apply for relief from removal if they fear persecution or torture in their home country. Those are the legal mechanics. 3 traps: statutory, procedural, constitutional. Any one of them would be sufficient to block the deportations. Together, they form what the judge called an insurmountable barrier to the administration's claimed authority. Now let me show you why this creates a logistical catastrophe that could push the administration toward open defiance of the courts. The deportation pipeline of 2026 is an industrial-scale logistics network. It was designed to move 1 million people per year. Think of it as a reverse supply chain: arrest, process, detain, stage, remove. The system only works if every node operates at maximum velocity. Detention beds are supposed to be high-turnover staging areas, not long-term warehouses. The average stay at the Alexandria staging facility in Louisiana is 72 hours. Detainees come in, get processed, get loaded onto planes, and leave. The entire network depends on constant outbound flow. The injunction just shut down the outbound node. Flights are grounded. But the inbound node is still operating at peak capacity. ICE is still conducting arrests at a rate of approximately 1,000 people per day. Some days, during what they call community raids, the number hits 3,000. Here's the math. The current detention population is 73,000. The theoretical maximum capacity, funded by the One Big Beautiful Bill Act, is 116,000 beds. That gives us a headroom of 43,000. If arrests continue at 1,000 per day and removals drop to 0, the system hits 100% capacity in 43 days. If arrests accelerate to 3,000 per day, capacity is exhausted in 14 days. When the system overflows, several things happen. First, ICE has to activate emergency facilities. Soft-sided tent cities like the one at Fort Bliss in Texas. These facilities cost $192 per person per day compared to $152 for standard detention. They're also nightmares from a legal compliance standpoint. The Fort Bliss facility, operated by a contractor called Acquisition Logistics that had never run a detention center before, faced allegations of medical neglect, beatings, and food shortages within months of opening. Second, regional staging facilities like Alexandria seize up. Alexandria can hold 400 people for 72 hours. It processes roughly 200 people per day. If flights are grounded for just 2 days, Alexandria hits 100% capacity. By the 3rd day, detainees are sleeping on floors. Medical staff are overwhelmed. The legal infrastructure for processing habeas petitions collapses. 20% of detainees were already being held longer than the 72-hour limit before the injunction. Now that number will hit 100%. Third, the aviation contracts start bleeding money. ICE doesn't own planes. It contracts with a broker called CSI Aviation, which subcontracts to various carriers. The standard charter rate is $8,577 per flight hour. The special high-risk charter rate, used for high-security cases, goes up to $26,795 per hour. When flights are canceled within 24 hours of departure, the government is liable for 100% of the charter price. Even at 48 to 72 hours, the penalty is 50 to 75%. ICE operates an average of 45 flights per day. If all of them are grounded, the daily dead loss and cancellation fees alone exceeds $1.5 million. Add in demurrage charges for planes sitting on tarmacs, roughly $900 per hour, and parking fees for wide-body aircraft at major hubs, $158 per day, and you're looking at a fiscal hemorrhage that will burn through the transportation budget within weeks. Fourth, and this is where it gets truly dangerous, detainees who are about to be deported are now stuck in legal limbo. Some of them have already been loaded onto buses. Some are at staging facilities waiting for flights that will never take off. The administration has two choices. Release them on alternatives to detention, which cost $4.20 per day but are politically unacceptable to the base, or keep them in custody at $152 per day while their habeas petitions work through the courts. If 50,000 people become stuck in this limbo, the daily burn rate is $8.75 million. Over a 30-day month, that's $262.5 million just to warehouse people who were supposed to be gone. This is the logistical nightmare, a system designed for velocity frozen in place, costs spiraling, facilities overflowing, and a political base demanding to know why the president can't just ignore a single judge in D.C. and finish the job. Which brings us to the historical warning. Because we've been here before, twice. And both times, the Republic survived only because cooler heads eventually prevailed. 1832, Andrew Jackson versus Chief Justice John Marshall. The case was Worcester vs. Georgia. Two white missionaries were arrested for living on Cherokee land without a state license. The Supreme Court ruled that Georgia's laws were unconstitutional, that the Cherokee Nation was sovereign, and that the federal government had exclusive authority over Indian affairs. The court ordered the missionaries released. Georgia refused. Governor Wilson Lumpkin ignored the Supreme Court's mandate. President Jackson refused to enforce it. Jackson's private letter to a friend captured his view perfectly. The decision of the Supreme Court has fell stillborn, and they find that it cannot coerce Georgia to yield to its mandate. By describing the ruling as stillborn, Jackson was acknowledging that the court's power was purely theoretical without the president's willingness to mobilize the U.S. Marshals or the military. Jackson justified his passivity through the doctrine of coordinate construction. He argued that, as a co-equal branch of government, the president had as much duty to interpret the Constitution as the Supreme Court. He was not bound by a judicial interpretation he deemed erroneous. But here's the thing, Jackson's stance was fundamentally transactional. During the same period, when South Carolina tried to nullify federal tariffs, Jackson threatened to send federal troops to enforce federal law. The contradiction was obvious. Support Georgia's right to ignore federal treaties while threatening to invade South Carolina for ignoring federal taxes. For Jackson, the supremacy of law was a tool of executive convenience, not a constitutional principle. 1861, Abraham Lincoln versus Chief Justice Roger Taney. The case was Ex parte Merryman. John Merryman, a Maryland secessionist, was arrested and detained at Fort McHenry. His lawyer petitioned Taney for a writ of habeas corpus. Taney issued the writ, ordering the military commander to produce Merryman in court. The commander refused, citing President Lincoln's suspension of habeas corpus. Taney responded by issuing an attachment for contempt. When the U.S. Marshal tried to serve it at Fort McHenry, he was barred by armed guards. Taney's opinion remains one of the most powerful judicial critiques of executive overreach in American history. He argued that only Congress could suspend the writ, as the suspension clause is in Article 1, which defines legislative powers. If the president could unilaterally suspend the writ and ignore judicial process, Taney wrote, the people of the United States are no longer living under a government of laws. Lincoln ignored the ruling. He provided his formal defense to Congress on July 4, 1861. His argument was the doctrine of necessity. Are all the laws but one to go unexecuted and the government itself go to pieces, lest that one be violated? Lincoln posited that his oath of office required him to preserve the government at all costs. If the rebellion succeeded because he refused to suspend a single procedural right, he would be violating his oath to protect the entire Constitution. Congress eventually regularized Lincoln's actions by retroactively authorizing the suspension in 1863. Those are the precedents. Jackson and Lincoln both pushed the boundaries of judicial authority. Both claimed the executive had the right to interpret the Constitution independently. But here's the critical difference. Jackson's defiance was resolved through political compromise. The missionaries were eventually pardoned. Lincoln's suspension was eventually authorized by Congress. There were off-ramps. There were mechanisms for restoring constitutional order. The 2026 standoff lacks an obvious off-ramp. Vice President J.D. Vance has been explicit. In public statements and on social media, he's urged the president to stand before the country like Andrew Jackson did and say, the Chief Justice has made his ruling, now let him enforce it. This isn't subtle. This is a direct call for the president to ignore the courts. And here's why that's different from Jackson or Lincoln. We're not talking about a single case in a single state. We're talking about a nationwide injunction affecting 73,000 people across every state in the country. We're not talking about a wartime emergency where the capital is surrounded by hostile forces. We're talking about immigration enforcement, a policy area where the president has always been subject to judicial review. If the president ignores this injunction, what happens? Judge Cotelli can hold administration officials in contempt. She can issue fines. She can order arrests. But all of that requires the cooperation of the executive branch. The U.S. Marshals who would enforce the contempt order report to the Department of Justice, which reports to the president. If the president orders them not to comply, the judge has no army. She has no enforcement mechanism. Her power, like John Marshall's in 1832, is purely theoretical. And if the president can ignore this injunction, what's to stop him from ignoring the next one? What happens when a judge orders the administration to unfreeze billions of dollars in federal grants, as happened in Rhode Island on February 10th, and the administration simply shrugs? What happens when a judge orders the administration to stop dismantling independent agencies like the Consumer Financial Protection Bureau, and the administration continues anyway? The answer is that we enter what scholars call a post-constitutional era, a system where the executive determines which laws to fund, which judicial orders to follow, and which constitutional rights to respect. James Madison warned about this in Federalist 51, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. I need you to understand the stakes here. The deportation injunction is not just about immigration. It's a test. The administration is deciding right now whether to comply with the courts or to cross a line that is held for 250 years. If they cross it, the constitutional order we've inherited is over, not damaged, not weakened. Over. The good news, if there is any, is that we're not powerless. Public pressure matters. Congressional oversight matters. The administration's approval rating is 37%. Independent voters disapprove of the president by a margin of 64 to 29%. The 2026 midterms are 10 months away. If Republicans in Congress believe that defying the courts will cost them their seats, they'll push back. But that pressure has to start now. Contact your representatives, especially if they're Republicans. Tell them that ignoring a federal court order is not toughness, it's lawlessness. Tell them that the rule of law is not a partisan issue. It's the foundation of the republic. Because here's the truth, the system is not broken yet, but it's bending. And if we don't act now, the next headline won't be Judge blocks deportations. It'll be President defies court order. And after that, there's no going back.